the defense verdict. So counsel, we are ready to begin. You may proceed. Yes.
Thank you. May it please the court, Your Honor, counsel. I represent Mr. Halprin. This case is here on a subsequent writ, which means it had to go to the Court of Criminal Appeals and receive authorization under Section 5. And when the Court of Criminal Appeals authorized this case to come back to this court, it made certain findings that I think are relevant here today. The finding from the Court of Criminal Appeals is essentially that Mr. Halprin has pleaded facts and stated a claim that if he proved it could lead to relief. Now the state has filed an answer and they take a different position. Basically what they argue is assume that all of the facts are true, and we've talked about the exhibits that the state has identified that Mr. Halprin is attached to his petition. And they involve certain affidavits, I believe some audio clip, and some newspaper articles. Assuming those are true, the law would not permit relief. In other words, Mr. Halprin hasn't pleaded a claim that the due process clause can address and remedy. And I'd like to address that, but I'd also like to address some of the implications of the state's position here today. Now, my understanding of it is, I think the state is treating this like a summary judgment motion, where the court would take facts and view them in a certain way. In other words, view them in the light most favorable to the position that the petitioner is urging before the court, and then determine if, as a matter of law, he is not entitled to relief. So really, I think what the state is mostly focused on in their answer is the law. Now, that being said, I don't want the court, because the court is not applying a summary judgment rule, it's applying 1107(1). And there's certain findings once a case comes from the Court of Criminal Appeals back to this court that the court is required to make. One is under Section 8, whether there's any disputed factual issues that need to be resolved. And I don't believe the court has done that yet. Where we are right now is, under the state's view of it, we're just going to view the evidence as being true. And did Mr. Halprin state a legal claim that would lead to relief? Now, if the court were to take a different view of the evidence, I believe Mr. Halprin would be entitled to evidentiary development. And we're not conceding that we're not entitled to further evidentiary development. But anyway, I would like to talk about the law at this point in time. Now, the state's position here is to show a due process violation. The Supreme Court has only identified 3 categories of judicial bias that qualify for a due process violation. One is where the judge has a pecuniary or financial interest at stake in the decision. 2, where I believe the litigant has done something to the judge, I guess abusive towards the judge. Or 3, where the judge is acting in a dual role. One as investigator or prosecutor, and later as a judge in the same case. Those are the 3 categories. And they say, if you don't fall in those 3 categories, you can't have what the state is referring to as a presumptive bias. And therefore you have to show an actual bias. An actual bias would be, okay, you've got your situation. Now you've got to show a direct positive impact on the trial proceedings. Our position is the state's view of the due process claim that we have here and what is required under the Supreme Court's due process test is too constrained. And you look at the cases that we cited, the Supreme Court has never limited due process to these particular situations. Now, due process requires a fair trial and a fair tribunal. That's the basic requirement. And that's the N. Ray Murchison case. And to me, the court said every procedure which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, which might lead him to hold him not to hold the balance nice, clear, and true between the state and accused, denies the latter of due process of law. Now, these are the initial cases that start talking about this due process standard. The court has addressed this a number of times, most recently in Williams and Caperton. And I would really like to focus on those two cases because they not only state the standard, the Supreme Court not only states the standard, but talks about it in application. Now, it's an objective standard. In other words, you don't have to go rattle around in the mind of the judge and show an actual bias. You look at the totality of all the circumstances and ask whether, based on all those facts, an average judge would be neutral or whether there would be an unconstitutional risk of bias. And the situations the court has identified, they've held that that threshold has been met. Okay. Now, in Caperton, which is a really interesting case, this case involved a judge who, a litigant, contributed a lot of money to a campaign, selected this judge essentially to be on the court and ultimately rule on that particular case. Now, the court states the standard, but then it applies it, and it talks about these categories that the state has looked at, and it doesn't say like, okay, the due process standard is a light switch. You flip it on, you flip it off. It's more like a dimming switch. You know, do you get to a certain level of brightness? You have a due process violation. But even in those categories that the court has identified, you can have insignificant situations that do not raise a due process violation. And I would hope that the court would look at Caperton real close because I think it applies in our situation. Our situation, I mean, we're not talking about an isolated incident. We're talking about something that is pervasive, that it's been lifelong. We're talking about a racial animus that informed why a judge would go into public office. we're talking about a racial animus that close friends observed over a long period of time. We even have a recording of his mother acknowledging the racial bias. We have evidence provided that not only did it inform why he would seek public office, but it was used during office, during his time, to refer to litigants appearing before the judge. But not only that, we have statements made specifically about the Texas 7 trial defendants and Mr. Halprin specifically. Now, the state would say, well, that happened years later. It didn't happen contemporaneously at trial. But the Supreme Court, in its standard, says you do not have to make that connection to make a due process claim. What you have to do is show that there's an unacceptable risk that that bias existed. And that goes back to Caperton. Here on page 883, continuing on into 884, that whole paragraph here, starting the difficulties of inquiring into actual bias and the fact that the inquiry is often a private one, simply underscore the need for objective rules. Otherwise, there may be no adequate protection against a judge who simply misreads or misapprehends the real motives at work in deciding the case. The judge's own inquiry into actual bias is not one that the law can easily superintend or review, though actual bias, if disclosed, no doubt would be grounds for appropriate relief. In lieu of exclusive reliance on personal inquiry on appellate review of the judge's determination respecting actual bias, the due process clause has been implemented by objective standards that do not require proof of actual bias. In defining these standards, the court has asked whether, under a realistic appraisal of the psychological tendencies and human weaknesses, the interest poses such a risk of actual bias or prejudgment that the practice must be forbidden if the guarantee of due process to be adequately implemented. Here, Judge. The situations that the Supreme Court addressed that we have a due process violation here involved, and to me, a $12 payment that the judge would receive on conviction of a defendant for possessing alcohol. Here we're talking about racial bias against people who appear before the judge. It's far, far more significant in this case than it is in some of the other cases where the court has found a due process violation. This case lies in a spectrum of cases that have come out of the Supreme Court addressing specifically racial bias. We have Millerell dealing with jury selection. We have Buck dealing with counsel, defense counsel. We have Rodriguez Pena dealing with juror bias. The state would have it that the due process clause would provide no remedy if the judge harbored racial bias. You have significant evidence that that bias existed throughout the course of all these proceedings. We asked the court to reject the state's position and recommend relief to the to the Court of Criminal Appeals. Like I said, if the court feels like credibility is an issue, we need to address those with the court and proffer what procedures would be appropriate to address that. Do you have any time left? Okay, then I'll reserve it.
Okay,
Thank you.
thank you. Now,
Good morning, Your Honor.
Good morning.
May it please the court, my name is Ann Grady. I represent the state in this matter. May I proceed?
Yes, you may proceed.
Certainly, the state agrees that violation of the right to a trial before an impartial judge constitutes a structural defect affecting the framework within which the trial proceeds, rather than simply an error in the trial process itself. And as such, it defies harmless error analysis. But simply, if Halpin has established that Cunningham was biased against him at the time of trial, there is no need to analyze the trial transcript for the number of objections sustained or overruled that would suffice to deem that error harmless. He would need show no further harm in order to be entitled to a new trial. But contrary to applicant's arguments, to establish a due process clause violation based on the structural error of judicial bias, either actual bias on the part of the judge must be shown at the time of trial, or the case must involve a situation that, viewed objectively, establishes an intolerably high probability of bias grounded in the judge's personal, substantial, and pecuniary interest in the outcome of the case, personal abuse of the judge by the defendant, or a dual role by the judge in investigating and adjudicating the issue at hand. Those are the types of objective circumstances that have been found to disqualify a judge without bothering to inquire about his subjective state of mind, and in fact, sometimes over the judge's protestations regarding his unbiased subjective state of mind. The law simply will not tolerate any of those objective circumstances to be allowed. But in cases such as this involving an appearance of bias and the judge's own personal biases and prejudices, the record must be examined to determine whether it demonstrates that the judge's bias affected the defendant's right to a fair trial and due process of law. Applicant has not sustained his burden of showing any of these bases for vacatur of his conviction. I want to also just touch on before I proceed this the question of the procedural posture of the case. Section 511.071 simply provides a procedural bar to bar subsequent WRIT applications such as this, unless they fall within certain categories of claims. This case fell within a certain category of claim, and therefore the Court of Criminal Appeals remanded it for further proceedings in a normal course. So we're back as if this were an initial WRIT, and away we go. That does not mean that they made any findings of fact. They, in fact, remanded it to this court to conduct a proceeding and to make findings of fact and conclusions of law. And I also, well, I think enough said on that. I simply will note, I believe I have this, that gaps in the application's proof do not entitle the applicant to an evidentiary hearing. Sworn pleadings of material facts are a prerequisite to the grant of an evidentiary hearing for the type of live testimony that can form a basis for relief. That was the Court of Criminal Appeals in 2011 and Ex parte Garcia. So in order to survive the pleading stage, the applicant must present sworn facts that, if true, would entitle the applicant to relief. And yes, a WRIT application which fails to meet that requirement of pleading is subject to summary dismissal, Maldonado. And of course, Judge, the Texas Code of Criminal Procedure, Article 11.071, Section 8A does also provide that a hearing to determine issues of fact before denial of a claim is required only when the court determines that there are controverted, previously unresolved factual issues material to the legality of the applicant's confinement. Since here there are no controverted or unresolved facts, no hearing is necessary before continuing. As I was saying, structural error, not subject to harmless error analysis, but that does not mean that the trial record is irrelevant. Under Texas law, when the defendant claims judicial bias, the court will review the record to determine whether the judge's bias denied him due process of law. Most often, Your Honor, will see these claims arise on direct appeal. The defendant, for example, throws a chair in the courtroom at the beginning of the trial proceeds, and then on direct appeal, the claim is made that the judge should have recused herself, that she was biased throughout. And naturally, the appellate courts will review the record of the trial to see not whether the error was harmless, but whether bias is shown in the first place. Here, the trial record is particularly relevant to this claim to determine whether the judge was biased against the defendant. That is because in the entirety of the record now before the court, the only contemporaneous statements by Judge Cunningham regarding his state of mind toward this particular defendant at the time of trial are to be found in the trial record. no other evidence has been offered by the applicant as to this judge's state of mind toward the defendant at or just before the time of trial, whether unbiased or biased. In that way, this case is very sharply in contrast to cases such as Berger, Norris, and Brown. In Norris, the judge made specific pretrial statements of personal, I believe, racial bias, and he expressed his own personal doubt as to whether he would be able to set those biases aside against Mr. Norris, and yet he proceeded. In Berger, the judge stated at trial on the record to the German-American defendants that he would rather try a case of a thief who was a good soldier over the disloyal German-Americans before him. Naturally, that was reversed. In Brown, just before trial, the judge spoke about the upcoming case and said that he was going to get that N-word. So the judge's state of mind is being expressed in those cases. Here, in contrast, the only statements indicative of actual bias toward this particular defendant were made years after the trial. In or around 2006 and 2007, when Cunningham was running for district attorney and just after that campaign. The language used in those statements, the ethnic slurs, were reprehensible, but they are not enough to support the inference that applicant is asking this court to draw, that Cunningham therefore harbored an actual bias against Halpin at the time of trial. That's because of the change of circumstances. First, there is the passage of years itself. Second, there is the fact that at that time, Halpin had been tried and convicted. Cunningham had seen and heard the witnesses against Halpin at trial. After conviction, Halpin was not only, whereas before trial, he enjoyed a presumption of innocence. After trial, he's not only factually guilty, he is legally guilty of the murder of a police officer. So Cunningham's hostility toward him at that time, whether that was appropriate or inappropriate, was understandable. Now, and the racial slurs that he used to express that hostility are consistent with the personal biases and prejudices that applicant has offered this court in evidence. But in terms of the actual bias against this particular defendant, while it is reprehensible and egregious, they show post-trial hostility that does not demonstrate a due process violation against this defendant at the time of trial. And I would call Your Honor's court, the court's attention to ex parte Freeman, where that distinction was pivotal. In that case, it was a revocation of probation hearing, and before the hearing, the defendant made threats against the judge's life. It proceeded. After the hearing, the judge came back out and approached defense table, and let's just say words were exchanged. After that, there was a claim that the judge was biased at the time of the probation hearing, and the court said there's no evidence that the judge knew about the threats on his life from the defendant before the probation hearing. Therefore, there's no evidence that the judge was biased during the probation revocation hearing when he imposed the sentence. That is what is lacking here as well. Upon a close reading of the application and hearing of today's arguments, I believe Your Honor will find that the applicant is not claiming that he has evidence of actual bias against him at the time of trial. Rather, what he is arguing is that Cunningham harbored longstanding animus towards and prejudices about non-white, non-Christian people, and that those views informed his thinking about public service in the law. Based on those contentions and those allegations, the applicant is saying that Cunningham's views create an objectively intolerable risk of bias in violation of applicants' due process rights, i.e. presumptive bias. And that's not the state that has coined that term to apply here. That is in the application at pages 29 to 30 and 54, that he is arguing that that qualifies as presumptive bias. However, applicant does not cite a single decision that supports that construction of the law. In my searches of the law, I could not find a single decision that supported that construction of the law. The United States Supreme Court's objective test for an intolerable risk of bias applies to 3 circumstances, none of which is present here. Mr. Halprin has not established the judge's personal, substantial and pecuniary interest in the outcome of the case, which was the case in the cases just discussed today, Caperton and Toomey. He has not shown personal abuse of the judge by the defendant, as I was saying, for example, throwing the chair in the courtroom or threatening the judge's life, nor has he shown a dual role by the judge of investigating and adjudicating the case at hand. Any of those 3 would establish an intolerably high probability of bias, aka what the Fifth Circuit has termed a presumptive bias. And I will note, Judge, the Fifth Circuit, where did I put it? As I discussed in my response, the Fifth Circuit has coined that term to distinguish the objective test from cases involving actual subjective bias. Quote, generally, the Supreme Court has recognized two kinds of judicial bias, actual bias and presumptive bias. That's Bunchen versus Quarterman, Fifth Circuit, 2008. And the Fifth Circuit has also observed that the due process violation based on presumptive bias has only been found in those three circumstances I was just describing. Bigby versus Dredke. It is in many ways comparable, as applicant points out, to implied bias on the part of a juror, where we do not ask the juror to engage in the expurgatory oath that, yes, I can set aside my biases and my connection to the case. Yes, I know I'm married to the prosecutor sitting at the prosecutor's table, but I can be fair and impartial. That's lovely, but no, thank you for playing, go. Those are the types of relationships to the case that there is no amount of statements of mind, the state of mind, that will overcome that. That is what the objective test pertains to. Here what we have is personal bias and bigotry. As I say, applicant is relying on Cunningham's personal bias against the Jewish religion and ethnicity to argue that he was disqualified from impartially presiding over this trial of applicant, a Jewish man. And at the outset, I just want to say that I just want to point out that under the Texas Rules of Civil Procedure, had it been known before trial that Cunningham harbored these very personal biases, that would not have required his disqualification from the case as a matter of law. Texas law provides for disqualification only in circumstances comparable to the Supreme Court's objective test: dual role, a personal or fiduciary interest in the case, or a relationship to the parties by affinity or consanguinity within the third degree. That's not to suggest, however, that personal bias and bigotry in a judge is unheard of. There are cases cited by applicant in his motion that highlight that this does go on, and that there are remedies for that, disciplinary proceedings. In the cases cited by applicant, judges were guilty of using similar racist language from the bench or in emails sent from their work computers. And as a result, they weren't properly publicly censured. They were sent for remedial training. And those kinds of disciplinary proceedings are the proper forum for confronting a judge's personal bias, including racial and ethnic bias that calls into question his or her fitness to sit on the bench. And I also want to point out that if Cunningham were to run for office again, the voters might provide an even clearer sanction. And that is in fact precisely what the voters did in 2008, when the Dallas Morning News' expose revealed this information, and the voters found Cunningham unworthy of being on the commissioner's court. It does not follow, however, that the law presumes that Cunningham's personal bias infected every trial of a minority defendant. That is because judges are presumed to understand their role and to follow the law. There are judges sitting on the bench right now, Your Honor, who are against the death penalty and have a motion to set execution on their desk. And the law presumes they're able to set their personal views aside and conduct themselves in accordance with the robe that they're wearing and the oath that they have taken. The U.S. Supreme Court has held more than once that to grant a relief to a particular defendant, the judge's personal biases standing alone are insufficient to establish a violation of the Due Process Clause. Rather, to rise to the constitutional standard of a structural error, some adverse effect of the judge's bigotry on the defendant's right to a fair trial must be established. Norris v. United States actually explains that very well. That was out of the 11th Circuit. And here, applicant has not shown and cannot point to any ruling or pattern of trial rulings that showed an impact of Cunningham's personal views on applicant's case. The one he relies on chiefly, the ruling against hearsay from his expert during the punishment phase, he also acknowledges was a rote application of the hearsay rule. And in fact, almost all of Cunningham's trial rulings were routine. They were consistent. They were identical with all of those that he had made in the previous 4 trials that he had presided over involving applicant's co-defendants. Applicant can't show a single ruling where the judge disallowed one type of evidence in one type of case involving one ethnic defendant, but was different in his case. Consistent with the rulings in the other trials, he excluded unduly prejudicial, gruesome autopsy photographs. The evidence seized from Colorado was one minor exception was the same as the other trials. And in fact, few of the trial rulings were unique to applicants. Therefore, it is unsurprising that when applicants' appellate attorneys reviewed and scoured the record looking for any signs of error, and they raised, I don't remember how many claims of error, but none of them highlighted any sign of the judge having hostility toward Halpin or being biased against him in any way, and certainly there was no pattern. The record, in fact, not only shows an absence of bias, but shows an affirmative showing of Judge Cunningham's determination to provide Halpin with a fair trial. At the time of trial, Judge Cunningham put his unbiased state of mind toward Halpin on the record, not once, but twice. The first was at the outset of the trial. Cunningham explained why he wanted leg irons or other restraints to be invisible to the jury. Remember, this is a case involving a defendant who had already escaped from custody, and leg irons and other physical restraints were deemed by the sheriff's office to be necessary. The judge explained to Mr. Halprin, the idea is, I quote, the idea is I'm going to provide you absolutely the fairest trial I possibly can with the minimum amount of restraint necessary, close quote. He also, as I was pointing out in my response, he made sure that civilian clothing was going to be provided, et cetera, so that there would be no prejudice to the defendant in the jury's minds that he just looks like a prisoner and therefore must be guilty. Then mid-trial, he said to Mr. Halprin, quote, this is your trial. My job is to make sure you get a fair one, close quote. In the record now before the court, those are the only statements that Cunningham made at or around the time of trial indicative of his state of mind. And they certainly provide the court no basis for vacating this judgment of conviction. They affirmatively demonstrate that Cunningham was aware of his oath to provide impartial justice and that his personal goal was to ensure applicant received a fair trial. I also point out that the judge succeeded in that effort. This trial has, the conduct of this trial has been reviewed by the Court of Criminal Appeals and by the Northern District of Texas and by the Fifth Circuit and has been upheld each time. I also point out that each of those statements made by the judge was accompanied by concrete actions designed to provide that very thing, a fair trial. First, the leg irons. Cunningham made sure that Halpin was not paraded before the jury in leg irons. The restraints were minimized to a security belt and possibly leg shackles that were outside of the jury, because we know that because then when Halpin was about to take the stand, Mr. Halpin was about to take the stand at trial, the judge reminded him, be sure you keep them, the leg irons out of sight while you're on the witness stand. And then he said, you know what? No, take the leg irons off. The sheriff objected, he said, take the leg irons off. The second time was after when Mr. Halpin was on the witness stand, and for that was the first time he had a vantage point of the prosecutors at the prosecution table, and he, in front of the jury, said, they're staring at me. And the judge quelled that, did not embarrass him in front of the jury, said, they're just taking note, they're just listening, continue. And it was only later, outside the presence of the jury, that Cunningham went into the question. And even then he expressed compassion and understanding. He remarked, quote, this is probably the first time you've had a direct line of sight. And I saw Mr. Worski and Mr. DeMori whispering to each other, being a calming presence to this trial. Now, applicant argues that tone of voice can't be discerned by reading a transcript, but even on a cold record, Judge, it is clear that Judge Cunningham was courteous to Mr. Halprin throughout the record, throughout the trial, and even at that point when he perhaps could have been excused for showing some irritation, he didn't show any personal pique. He instead felt concerned to protect the applicant's right to a fair trial. And even when Mr. Halprin apologized, Judge Cunningham said, no, this is your trial. My job is to make sure you get a fair one. In short, Judge, the record of the trial does not offer a clear showing of bias, but the reverse. The record shows that Judge Cunningham was well aware of his role in ensuring impartial justice, both through statements by him that his job was to make sure applicant received a fair trial and by his actions accomplishing that goal. The record refutes the inference that applicant wants this court to draw that Cunningham's personal bias, no matter how reprehensible, no matter how lifelong, the record refutes the notion that that bias infected the fairness of applicant's trial. Courts generally presume that public officials have properly discharged their official duties, and bias by an adjudicator is not lightly established. Quote, in the absence of a clear showing to the contrary, reviewing courts will presume that the trial court was neutral, detached, and unbiased in all phases of the trial. That's just from some of the decisions cited in my response, Judge. I'll just conclude by just concluding that applicant has not established actual bias against this defendant at the time of trial, nor has he established that Cunningham's personal bias affected applicant's trial. Without that nexus between Cunningham's personal biases and applicant's trial, the law is clear that Cunningham's racism and bigotry standing alone are insufficient to establish a violation of this particular defendant's rights under the United States Constitution so as to require vacatur. Unless the court has any further questions, I'll rest on my response. Thank you.
Your bill, Mr. Mason.
Just for purposes of clarification, we do talk about the due process standard at length in our brief, and we urge the court to apply it in a certain way. But the evidence itself, we believe, does show an actual bias, and we don't want to have the court misapprehend that that's not a contention before the court. Now, if I understand the state's argument, and I would go back to that quote that I had from Caperton earlier, where we talk about you don't have to go rattle around in the judge's head and come out with evidence of an actual bias at the time of trial. You have to have this unjustifiable risk. But if you draw a line through all the evidence that we have of this lifelong pervasive attitude, racial animus, bigotry, before the trial and after the trial, and while he was on the bench during this trial, you draw a line straight through, I think it's inescapable that you're gonna have to find an actual bias was present during this trial. It's kind of like saying a leopard has spots on Monday, it has spots on Friday. We have pictures of that, but you didn't prove, counsel, that the leopard had spots on Wednesday. They don't have a picture of it. I mean, circumstantial evidence and inferences are very fair in applying the standard, Your Honor. Some other matters that are raised in our brief that merit discussion. It's not only due process that's involved here, Your Honor. It's primarily due process, but because of the nature of this claim, it's not just racial animus, it's ethnicity and religion. So we have a free exercise issue as well. State talks about some Fifth Circuit cases that are cited in their brief, and says that the Fifth Circuit has interpreted the Supreme Court cases in a certain way. Actual bias and presumptive bias. I believe one of the courts and one of the cases cited does refer, I think it's Bunchen, refers to presumptive bias and talks about these three categories. I would point out that I believe these cases were decided prior to Williams and Caperton, which are the most recent Supreme Court statements on this standard. Not only that, they are applications of, I believe, the Anti-Terrorism and Effective Death Penalty Act, which constrains federal court review in certain very narrow boundaries, and one of which is that you have to show an unreasonable application of the state court applying clearly established federal law in an unreasonable manner. But also, you have to have clearly established federal law as articulated in a Supreme Court opinion. Okay, so if the Supreme Court has said in talking about the due process claim, they've identified three circumstances. Look at the Supreme Court cases. They've never limited it that way, and I believe that's the clear implication from Caperton and Williams. This court is not constrained by that. This court is looking at this de novo. So what are we talking about here? We're talking about anti-Semitism. And you can look from here back through history, take a century, and the pages of the history books are just littered with the bodies of murdered Jews. I mean, this is not insignificant. This is pervasive. And I believe the due process clause can reach this situation, and this court should do so and should hold as much. The remedy that the state proposes is sufficient. Yeah, you're right. The state, you look at the Supreme Court and how they talk about judicial disqualification or recusal. Yeah, the state provides remedies, but sometimes the due process clause trumps that. It's a floor. Provides the ultimate protection. This is a case where the due process clause must provide a remedy. It's too late to say, oh, well, he's subject, Cunningham's subject to censure or voter approbation or whatever. It's too late. And the nature of the case, Your Honor, I mean, this is as serious as it gets. You just can't have cases like this infected with kind of attitudes and evidence that we have, and that the state has basically said, assume all of this is true. We'd ask for, once again, recommend relief. And before I forget, I don't know if this is necessary, but we would offer all the exhibits that are attached to the petition into evidence. We'd ask the court to consider everything.
The court will consider those exhibits that are attached all.
Thank you, Your Honor. I believe that's all I have.
All right.
Unless you have any questions.
Thank you, Mr. Mansour. Okay, so let me tell you what I will expect from counsel. 30 days for your proposed findings. And I don't have the parties file, whatever findings you feel are appropriate. I will make a decision at that time once I receive your findings. That takes us to August 13th. That's going to be your deadline to get the findings in. My preference is that you all submit those electronically in Word format and file them with the court. Does either counsel have any questions or anything else that you believe needs to be put on the record today?
May I have a second?
Sure.
Yeah, just as a housekeeping matter, if the court is finished with Mr. Halprin, I believe he'd like to return to Livingston.
Oh, okay. Oh, sure. Yeah, we'll be finished with the hearing, but hold on just a minute. Everything else I'll need on the record.
I just have one question, Your Honor.
Yes.
If there's any difficulty filing it in Word format and we need to file it as a PDF, as I think is more, would you like us to email you a courtesy copy in Word format?
Yes, that would be great.
Thank you.
Yeah, that's probably best when you file it there, file in PDF. Okay, well, there's nothing further from either counsel. This concludes the hearing on the Halpin writ. All parties are excused and the court will be in recess.